Let me know if this works. There you go. Sorry about that, guys. So let's start from the beginning. Welcome. My name is Lior Samfiru. I'm the employment lawyer. And I'm here, as I always am, to talk about employment law and to answer your questions. So, I'm one of the founding partners of Samfiru Tumarkin LLP. And every week I log on here to give you the opportunity to ask me questions, to pick my brain, to make sure that you have answers to your employment law issues. Maybe it's a situation where you've been let go and you're staring at a severance offer. Let's talk about what that is, what you're owed, what to do about it. I'm going to talk about that. Maybe it's a situation where you're being mistreated by your boss, by the owner of the company. What to do, what to say. Ask the question. Maybe your job is being changed. Maybe it's a vaccination question. Whatever the issue, whatever the problem, I promise you there are answers. There are solutions. There's things that you can do about it. And it starts by asking this question right now on here as you're watching me. So I'm going to start answering questions in a moment, but I want to encourage you not to be bashful. I want to encourage you to have the confidence to stand up for your rights. And it starts by asking a question, by understanding, by giving yourself an opportunity to learn about your rights. Again, my name is Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. We operate across Ontario, BC, and Alberta. And every week I'm answering questions. Let me give you another way to contact me and my team. If what I say here triggers more questions, or you want to have a private chat or email exchange with me and my team, easy. All you do is you go to employmentlawyer.ca. You see that address at the bottom of the screen, employmentlawyer.ca. Phone number is there. Email address is there. It's all there. So take advantage. Use it. It's the easiest way to connect with me. We try to make it as easy as possible. But that's for after. Right now, I'm live. You're live. Asking questions. I'm answering questions. You have a question about employment law, workplace rights, your job, your legal entitlements. Ask it right now. I'm going to start answering some questions. First question is from Shayla on YouTube. How long do you have to sign a severance offer? And can it be taken off the table? So, Shayla, every severance offer has a deadline. So your employer is going to give you a deadline. You have to sign this by Friday, by Tuesday. That deadline is meaningless. Your legal rights don't expire Friday at 5. In fact, your legal rights don't expire for 2 years. All that deadline is a pressure tactic. What you need to do is to make sure that you get what you're owed. Here's what happens in most cases. You're owed 12 months severance. Your employer is offering you 5 months, and they say you have to accept this by 5. But by Friday at 5. Well, wait a second, I'm owed 12. Why would I even consider accepting 5 months when I'm owed 12? That's what happens in 90% of cases. So don't worry about that then. You have 2 years. Your rights don't expire for 2 years. If you lost your job, if you have a severance offer, you have to call me. You can email me, my team. You go to employmentlawyer.ca. We can tell you what you're owed and talk about how we get you what you're owed. It's not a complicated process. It's easy to get what you're owed, but you got to reach out. So again, employmentlawyer.ca, Shayla. All right. Next question from N. Stinson on YouTube. Longtime viewer here and on TV. Great shows. Thank you. Does federally regulated company have the legal right to transfer a department of 100% remote, non-union, full-time employees from one site to another in a different province away if the employee remains 100% remote? So I'm not sure I understand the question. Can they transfer you to another province? If you're working, so if you're working from home, they can do what they want as long as it doesn't really change your job in that significant way. Now, if you're looking at more than 10% reduction in pay, that could be a constructive dismissal. So if you're facing a change, we need to talk about it, right? It's nothing to do with whether it's federal or provincial. The law is exactly the same. It's a question of how does this impact you? So I want to understand how does this impact you from a work standpoint, from a compensation standpoint especially, because beyond a certain level, it may be considered a constructive dismissal. And that would give you the right to say by making this change, it's as if you've terminated my employment. Now you have to pay me my full severance. And depending how long you've worked there, you could be owed as much as 24 months severance. Okay? So devil's in the details, right? So you want to reach out to me through employmentlawyer.ca so we can actually get going and understand what you're facing. All right, next question is from Mike on Facebook. My employer is only paying me for half days for stat holidays. They say this is done to compensate for sick days taken. Can they do this? No, they cannot. They have to pay you for your full days on statutory holiday days. If they don't, you can file a complaint with the Ministry of Labor. To the extent that you owe them money, maybe you do, they can't deduct what you owe them from what they owe you. That's illegal. That's a breach of employment standards. So you can go to the Ministry of Labor, file a complaint, because no, that is not legal, Mike. See how easy it is to ask questions? He asked the question, he got the answer, now he knows, and he knows what to do. Same with you. If you have a question, an issue, a problem, a dilemma, whatever the word is, ask your question right now. I'll see it, I'll read it, I'll answer it. And for those joining us, welcome. My name is Lior Samfiru. I'm the employment lawyer with Samfiru, Tumarkin, LLP. Answering questions. I'm going to continue answering questions right now. Next question today comes from Mary on YouTube. If I sign a contract that has a clause to allow the employer to reduce my salary, how much can the employer reduce my salary without being considered a constructive dismissal? Great question, Mary. So generally speaking, if your employment agreement says we have the right to reduce your salary, it will never be a constructive dismissal. A constructive dismissal happens when the employer does something that they're not allowed to do. But if you agreed in your employment agreement to allow them to reduce your salary, then they're allowed to do it, and it's not a constructive dismissal. So that's why that employment agreement is so important. You do not want to sign that employment agreement without knowing what you're signing, because you may sign an agreement that says we have a right to reduce your pay, we have a right to change your job, we have a right to demote you. That's a huge problem. Obviously, I haven't seen your employment agreement. So if you want a specific answer about your specific agreement and what it does and what it doesn't do, contact me off air, send me a copy of it, and I'll tell you. But generally speaking, if you've given them the right to do something and then they go ahead and do it, it's not a constructive dismissal. To reach out to me again, employmentlawyer.ca to reach me. Phone number there is email address is there. You can reach out to me at any time. So don't hesitate to do that. Right now, I'm live. Lior Samfiru here, the employment lawyer, answering questions, getting a few coming in. That's great. So don't be bashful. You have time. Ask yours now. Don't wait till the end of the session. Ask yours right now. Next question is from Rocket. Disciplined by my supervisor, and he allowed another worker who had nothing to do with what happened listen on why I was getting disciplined. Instead of going one-on-one, he embarrassed me. Can they do this? Well, it's not even a question of can they do this, because you can't call the police. It's a question of what you do about it. To the extent that you were embarrassed, and depending on the circumstances, that could be a constructive dismissal. If you're at a point where you're saying, well, now people are talking about it, how can I show my face at work? It's embarrassing for me. Them doing that, them putting you in that situation could be a constructive dismissal. So you only have two options. Either you kind of let it be, that's obviously all right, or if it is bad enough what happened, you may be able to treat that as a constructive dismissal. So there's no police that you can call to get someone arrested because they did something that they shouldn't have done, but that may be a constructive dismissal. If your boss does something that makes it difficult to continue working, that creates an embarrassing factor for you, that lowers your stature in the workplace, absolutely that could be a constructive dismissal. So Rocket, if you want to talk about that, let's connect off air. You know how to do that, employmentlawyer.ca, again, employmentlawyer.ca. But right now, I'm continue answering questions. We have questions coming in. I love that. That's my priority here, to answer your questions. Next question is from Jason on Facebook. I work for a marketing agency full-time, but have found out that they have lost 2 client contracts. 90% of my work is for these clients. Will this have the effect on the amount of severance I'm owed? Well, no, it's not. If because of this situation, you lose your job, then they have to pay you severance based on what you were making before. Here's how it's going to impact your severance. If they reduce your pay, you continue working, and then they let you go, then at that point, your severance is going to be calculated based on your income at the time. But if you lose your job now, no, it doesn't affect your severance. There's another thing you can do. If they come to you and say, well, because we lost these big contracts, we have to reduce your pay. We can't afford to pay you the same. That's a constructive dismissal. So you can treat that as a termination and require them, make them essentially pay you your full severance. So if you lose your job, you call me. If your salary is reduced, you call me. And I'll make sure you get your full severance, no discounts, no haircuts, you get your full amount, okay? To connect with me, easy to do. You know how to do that. Employmentlawyer.ca. Again, employmentlawyer.ca. Okay, let's see. I want to make sure I'm not missing anything. Okay, yeah, I answered Jason's question. N. Stinson has a follow-up question. The company has work sites in multiple provinces. Main impact on duties would be more stress, and impact on compensation would be loss of existing annual bonus of around 5%. Unfortunately, that's not enough to be constructive dismissal. The more stress, I get that, believe me, I understand, but that's not going to help, unfortunately. And 5% is not something you want, right? No one wants a 5% cut. I get that completely, but it's not enough to be a constructive dismissal. So it doesn't seem in this situation that there's going to be a constructive dismissal here, N. Stinson. Next question on YouTube from Sim N. 16-year manager in telecom was put on unpaid leave February 1 due to the vaccination status. Have been on unpaid leave since then. My employer has replaced me. Do they have to take action with the mandate removed? Well, here's the thing, Sim. They didn't have a right to put you on the leave to begin with, regardless of the mandate. So, yeah, you are owed severance. You only have two options right now. You can sit at home and wait and see if they do something one day. That is your right. Or you can treat this yourself. You can make the decision yourself now to treat that as a termination of your employment. You could have done that back in February. You didn't have to wait. You can certainly do that now. In fact, if anything, your case is even stronger now. So you absolutely can treat that as a termination. You absolutely can get severance. And if you've been there for 16 years as a manager, you could be looking at north of 18 months severance, okay? 18 months or more. So you have to contact me. You ought to reach out as soon as possible, okay? I wouldn't wait on this. Employmentlawyer.ca, again, employmentlawyer.ca. Phone number is there. Email address is there. Forms are there. Everything you need to connect with me and my team. We have an amazing team across Canada. Employmentlawyer.ca. Mary Song says, follow-up. Does it mean that an employer can legally reduce my salary to minimum wage if I sign the contract? Yeah, it does. If your employment agreement allows them to do that, if you've given them the right to do that, then they can do it. When people look at an employment agreement, usually they look at the salary. What's my salary? How many weeks vacation? Do I get a bonus? That's what people look at, and I understand that. But there are other things, potentially even more important, that you have to look at. And one of those things is, does the employment agreement, the employment offer, allow them to change your pay? Because if it does, essentially you're saying, hey, I'll come into work. You just pay me whatever you want to pay me, employer. I'm cool with it. That's a terrible thing to agree to, right? So you have to pay attention to these things. But again, I can't answer talk to you about your situation specifically because I haven't seen the agreement. But what you have to always ask yourself is my employer doing what the employment agreement allows them to do? If they're doing it, then usually it's fine. If not, then it's a problem. It's a constructive dismissal. All right, continuing here. By the way, those joining me right now, welcome. Thank you for joining me. My name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. We practice employment law and disability law across Canada, specifically in Ontario, BC, and Alberta. I'm here live right now. Hey, yeah, live. Whoa. Answering your questions. That's why I'm here. So please ask them. Don't be bashful. Don't wait till the end because if you do, I may not get to it. So ask your question. All right, next question from Fortress Maximus. My long-term disability was not approved as the insurance company is claiming they need more information, despite the doctor sending all my medical documentation to them. The information they are requesting is from an earlier period when I was on STD. It's my previous doctor who had retired, and I don't have access to her clinical notes. Well, you need our help here. We need to sit down with you and review and tell you whether or not they're entitled to this, in which case we'll have to provide them or find a way, or if they're not. And if they're not entitled to it, then we'll deal with them and we'll get them off your back and make sure you get your long-term disability. Remember, they're going to try to find any reason to deny your LTD or to cut you off. Any reason. Sometimes and many times, those reasons are nonsense. So I need to understand exactly what your condition is, how long you've had it, and all the facts and exactly what they're asking for. So I wouldn't wait on this, Fortress Maximus. You want to reach out to me. We have a whole team at my firm dealing exclusively, with disability rights and insurance companies. So employmentlawyer.ca, the way to do that, again, employmentlawyer.ca to connect with me. This is not something you want to wait on. This is not something you want to try to deal with yourself, You have to reach out. Okay, next question from JC 2004. If a private corporation closes up before paying out its severance obligations, can the shareholders or directors be sued? I've heard of that being done in non-employment-based civil suits. Generally, no. The only time you can sue them personally for severance is if they did something illegal, like they drained the money or they paid the money to their spouses, or they did something to avoid having money in the company to pay you severance. In those cases, you may be able to sue them personally, but generally, no. It's the company's obligation. But the fact that they shut their doors doesn't mean you can't get severance. The only time you won't get it is if they're actually in formal bankruptcy. That's very different than closing their doors. And because they have assets, they have accounts receivable, they may own property, they may own buildings, they may own equipment, materials. So they still have to comply with severance. So the fact that they may have closed down shop, they put an out of business sign on the door, does not mean that they don't pay severance, does not mean that they can avoid paying severance. The only time that you may not be able to pursue severance is if they're in formal bankruptcy proceedings. That's the only time, So there you have it, JC. If that's your situation or someone you know, you want to reach out to me as soon as possible. Again, employmentlawyer.ca. Employmentlawyer.ca. Okay, next question is from Ollie on YouTube. I lost my job and I'm unionized. I have followed union process. My manager terminated, and I have never had a reprimand in 14 years. What will be my rights? Well, only the union can answer that, If you're a unionized employee, the union is the only one that can advise you and the only one allowed to help you. There's no other option other than for the union to file a grievance. So only the union can tell you if you have a good case, if it's a bad case, what your rights are, what can happen. And by the way, everything that I talk about on this session does not apply to unionized employees. It only applies to non-union employees, Union employees is labor law, non-union employees, what we talk about here, employment law, Let's see, next question from Rocket. How long do I have to pursue this embarrassment in the workplace matter as a constructive dismissal? Not long. So I would say within 1, maybe 2 months at tops after the incident happened. Anything more than that, forget it. You're not going to be able to do it. So the sooner the better. Generally speaking, when it comes to constructive dismissal, when your employer does something and you want to treat it as a constructive dismissal, time is of the essence. You have to deal with it, and you have to deal with it quickly and in a timely manner. So if this happened, you cannot sit on that, Even 2 months, I think, is stretching it. But that would be the absolute maximum I would even consider it. All right, some great questions today, guys. My gosh, love those questions. So ask yours right now, employmentlawyer.ca to connect with me off air, but right now I'm live. All right, Claude on Facebook has our next question. I'm a 37-year employee and have been off since March 2020. My employer is taking advantage of the temporary ESA rules by not calling me back until government stops changing the date. So first of all, those rules don't apply, really. Those rules are meaningless. They don't do anything. You could have decided to treat this as a termination back in March of 2020, You could have absolutely done that. It does not apply at all. Bottom line is, if you're being put on a layoff, you can treat that as a termination despite the infectious disease emergency leave that the Ontario government has implemented, The law is very clear on that. So whether the government changes the date, extend it again, which I don't know. They may. I don't think that they will, but they may. But that's not relevant. What's relevant to you is, do you want to continue waiting, or do you want to treat it as a termination? If you want to treat it as a termination, you've been there for 37 years, you're easily going to be owed 2 years pay, 2 years, 24 months. You need to contact me right away. And anyone out there as well, if you've been put on a layoff because of because of COVID, even though your employer may say that's an infectious disease emergency leave, you have a right to treat that as a termination now. You don't have to wait. Okay, you don't really care what the government does in July. You can treat that as a termination right now. All right. Wow, lots of questions today. Great. Next question comes from Denelda on Facebook. I work in a restaurant, and my employer has asked that front of house staff stop wearing masks, but other members of staff are still required to wear them. Are there different restrictions for wearing masks for different positions? Well, no. Right now, there's no law that requires anyone to wear masks except on trains and planes. So it's up to your employer. So your employer doesn't have to say that everyone is the same in terms of wearing masks. Now, if you're not comfortable if you're not comfortable taking your mask off and you want to keep that on, your employer should allow you to do that. But they don't have to say everyone is the same. They can say people in the back wear masks, people in the front don't wear masks. That's okay, because the law says no one has to wear masks. It's up to the employer. Okay, but certainly if you're comfortable wearing a mask and you don't want to stop wearing it, they should let you do that. All right. You got what it takes on YouTube. Great name. Has the next question. Have been on a personal leave of absence, caring for ill family member, just passed away. Returned to work date unknown on my record of employment. Requested extension leave. My employer said I return to work or resign. So generally speaking, your employer in that situation is not legally required to give you a leave. It's up to them. So if they say no and you don't come back, that is a resignation. For just humane reason, they should give you a leave. But from a legal standpoint, they're not required to give you a leave. So because of that, the problem is if you don't go back when they say that is a resignation. Here's an idea. Maybe the stress of caring for the family member and them passing away makes you feel a bit sick. Talk to your doctor. If you get a doctor's note saying you can't work for a while, then they have to allow you to be off. But you have to have a doctor's note for that. It's not up to me. That's up to your doctor. If your doctor agrees, they'll give you a note and you're fine. Without a doctor's note, you do have to go back when your employer says. Okay, hopefully that helps. All right. SimN on YouTube has a question. How long does it normally take for a wrongful dismissal case to get resolved? Do they usually go to court or settled outside? Well, on average, it takes a few weeks, okay? 3-4 weeks or so to resolve. Most cases, probably 80% of cases are going to resolve within a few weeks. And 99.5% of cases resolve without even seeing 100 feet of a courtroom, okay? So going to court does not happen in wrongful dismissal cases, except in rare cases. They resolve, and that's why you should never be afraid of the process. So many times people say, I don't want to be involved in a legal action for 3 years. Nonsense. How about 3 weeks, okay? So don't be afraid of the process. We can resolve it quickly, easily, because we know what we're doing, okay? And as soon as the company sees our name on the letterhead, they say, crap, okay, now we have to pay. So that's just the way it is. Happy to chat with you if you lost your job. Again, employmentlawyer.ca. All right. So Silas says, if you're terminated, they owe you 2 years pay. Well, no. Your severance is based on 3 factors: your age, your position, and the length of your employment. The longer you work, the older you are, and the more senior position you have, the more severance is owed to you. So it could be 2 months pay, it could be 10 months pay, it could be 24 months pay. We had someone there that's been there for 37 years. He's going to get the maximum, which is 24 months pay. But Silas and anyone else, here's how you can find out how much severance you are owed if you're terminated. If you want to find out right now how much you're owed, easy. You grab your smartphone, you grab your tablet, your desktop, whatever you want, and you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. When you go there, you'll see our severance calculator tool. Our severance calculator is free. It's anonymous. It's easy to use. You answer a few questions. You don't have to put in your name, credit card, nothing like that. And it's going to tell you how many months of severance you're owed if you lost your job or if you're going to lose your job. You can even calculate that for you in dollars, okay? So the easiest and most accurate way to find out how much severance you are owed, pocketemploymentlawyer.ca, use our severance calculator, okay? So hopefully that helps. Shayla asks, is there a deadline to sign a severance letter? I answered that right at the beginning of the session. Your legal rights don't expire for 2 years. So the deadline on the severance letter is meaningless. 90% of the time, you're offered a lot less than what you're owed. So if you sign it, you give up your rights. Talk to me, talk to my team. We'll tell you how much you're owed. If what you've been offered is fine, then you'll sign. If it's not fine, we'll get you what you're owed. All right. Teresa on YouTube. My employer wants to have a pre-hearing meeting in August to answer questions. My hearing date is October. Should I attend the pre-hearing? I don't know exactly what hearing we're talking about, so I can't answer that. I don't know what kind of hearing we're talking about. Next question, AJA on YouTube. Employer said that I will be terminated after my 4-week unpaid leave of absence for being unvaccinated. Shall I wait for a termination or pursue constructive dismissal while on a leave of absence? Well, if you know that they're just going to flat out terminate you, may as well wait for that. That we don't even have to do constructive dismissal. If they were just keeping you on there indefinitely, then we would do constructive dismissal. If you're flat out going to be terminated, then let's wait for that. Call me as soon as that happens. We'll make sure you get what you're owed. They're probably not going to offer you any compensation. And in fact, they're probably going to give you a record of employment that disqualifies you from EI. We can get you severance. We can get you a proper record of employment so you can get EI. If you lose your job, employmentlawyer.ca. Next question from Clinton on YouTube. Wondering if I should contact you. I thought I had been hired by the city of Toronto as they had given me an employee number, but it turned out I was not. Too long to write here. Then, yeah, there's not even a question. Of course, you should contact me. Employmentlawyer.ca to do that. JC 2004. Are there many employers pushing for the monkeypox vax? I didn't even know there was a vax for that until yesterday. I have not seen any or heard of any employers yet pushing for this, so I'm not aware of that. Shayla says, can the severance offer be taken off the table? Well, here's the thing. It's a question of whether it's appropriate or not. So let me give you an example. If I owe you $100, but I say to you, I'm only going to pay you $30, but you have to accept this by Friday, then what? Am I going to take the offer off the table? And if I do, so what if I do? Because I owe you $100. So don't worry about that offer being taken off the table. Your legal rights don't expire. It's not the company's decision whether they want to pay severance or not. The law says that they have to. So just like I can't decide not to pay you if I owe you $100, they can't decide not to pay you if they owe you 18 months severance. The worst thing that you can do is to sign off on that severance letter, because then you'll realize you're owed 2, 3, 5 times that, and then you can't go back. Every week I speak with people in exactly that situation. So please don't let that happen to you, no matter what. Don't let that happen to you. All right, I think I've caught up on the questions and right on time because our session now is at an end. So thank you. What a great bunch of questions today, guys. You guys asked tremendous questions. Thank you for that. Again, my name is Lior Samfiru. I'm the employment lawyer with Samfiru, Tumarkin, LLP. You can contact me. I've told already a bunch of you. You got to reach out to me. To do that, easy, employmentlawyer.ca. Again, employmentlawyer.ca. And I'll connect with you by phone, by email, whatever you want. I'll be back on here, but don't wait until then. Reach out to me and my team right now, employmentlawyer.ca. Thank you for joining me. Lior Samfiru here, wishing you all the best. Take care.